Oh my, the second-headed monster, taxes. What kind of taxes? Oh, hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, great to see you here today. Folks, today I'm going to answer the question, how does state and federal taxes impact your estate plan? Folks, pull up a chair, take your best notebook out and pen, and let's learn together. The tax man is this metaphorical second-headed monster. Most of our clients want to slay that beast, okay? And is tax planning permitted within estate planning that will allow you to do that? But again, the devil is in the details. You need to be working with an experienced estate elder law attorney that is familiar with the tax code in these permissible tax planning strategies. Folks, I often say there's all different types of flavors of taxes, okay? So we're going to tackle 4 of them here today, okay? What are the taxes, generally speaking, that impact a person's estate plan, okay? Number 1, the first and foremost thing to look out for on the client's behalf is the estate tax. There's a federal estate tax on the current law, which is really high, over $12 million per individual. Most of our clients do not have to worry about that. Then there's a thing called portability. Married couples can double it and so forth. That's a federal estate tax, okay? Not so concerned about that. But some folks do have to be concerned about that, affluent individuals. And what I'm more concerned about is the state estate tax. And what you ought to know, folks, there's only 12 states currently that still have a state estate death tax. Here in the Commonwealth of Massachusetts, it's one of the lowest in the land, Massachusetts and Oregon, because the threshold for the state estate death tax is only $1 million here in the Commonwealth, okay? That being said, if you are a resident of the Commonwealth, you want to run your numbers on the Massachusetts estate tax calculator, because if you're $1 over, it's about 18 grand owed to the Massachusetts Department of Revenue, the taxing authority. From my experience, $1.2 million estate, about 50 grand owed, and it goes up the more that you have, okay? So really, really important to keep an eye on that. So that's the first tax you want to take a look at and consider and plan around, the estate death tax, okay? Meet with your estate elder law attorney right away and find out what the rules are and what the threshold is in your state if the state estate tax applies, okay? Folks, moving on from the estate tax. Also, the second tax that I'm often concerned about for folks within estate situations is capital gains tax. Capital gains tax is usually like a sales tax because a capital gain is usually realized or has to be paid when an asset is sold, okay? So say Bill and Mary own a home, they purchased it for $50,000 50 years ago. They want to avoid probate, so they add their son or daughter's name to the deed. Sounds great, right? Not so well, because they'll avoid probate when Bill and Mary die, but now their son or daughter that they gave what they call an inter vivos lifetime gift is going to take Bill and Mary's what they call carryover basis, the original purchase price, $50,000 that they paid for that house 50 years ago. Now the house is worth $650,000, okay? And their son or daughter go to sell the house because they do not need to live in it. They have their own home. They might live out of state, and they sell it for $650,000. Do the simple math. $650,000 minus $50,000 is what? That's right, $600,000 gain. Since the parents put their child's name on that property with that lifetime inter vivos gift, $50,000 minus $650,000, there's a $600,000 capital gain times the capital gains tax rate, interest rate, which is currently about 20%. 15% federal, 5% state, generally speaking. So 600 times 20 is how much? That is correct. Wicked math, $120,000 capital gains tax that child inheriting that property would have to pay because their name was put on the asset prior to. So really, really important, work with your state elder law attorney where they can build in language into your trust as a grantor trust to comply with the Internal Revenue Codes, usually 671 through 679. They put this other important language in there called limited power of appointment and things of that nature to qualify your trust, revocable or irrevocable, as a grantor trust. That way you're giving your loved one, your Mo, Larry, and Curly, a stepped up tax basis so they acquire what they call the date of death value, not your carryover basis, but they're going to get the date of death value of your property. Again, that was $650,000 in our example. They're going to get the property value at $650,000. They're going to sell it for $650,000, and result $650 minus $650. Wicked math, zero capital gains tax. Big game changer there in that situation. And that's under Internal Revenue Code 1014 of the code right there. Really, really important planning tool. Moving on, folks, let's talk about inheritance tax. There's only about 5 or 6 states that still have an inheritance tax. Make sure you check with your attorney to see if your state has what they call an inheritance tax. Inheritance tax, by the way, the big distinction is a lot of folks get it confused with the estate tax. An inheritance tax, some states, I believe it is Maryland, has both a state estate tax and an inheritance tax. So your estate would pay the estate tax, and then your beneficiary would also pay an inheritance tax based on what they were receiving in addition to paying the estate tax. That's a double whammy. That's the inheritance tax, okay? Lastly, folks, we're going to talk about income tax. Income tax is so important when it comes to estate planning. Income tax may be on your qualified retirement accounts like your IRA. You're passing that on to a spouse. Most spouses will do a inherited IRA rollover to the surviving spouse, and that's pretty clean, and that surviving spouse will take your IRA now in their name, and they will not need to start taking out what they call required minimum distributions under the Secure Act until they're 72 years of age. And under the Secure Act, they can stretch that out because they're qualified as an EDB, eligible designated beneficiary, okay? But not many people can qualify as that eligible designated beneficiary. If you're a non-spouse, folks, inheriting an IRA, then usually it's a 10-year rule under the Secure Act. You have to start taking out the proceeds or the asset of that IRA. For example, if it's a $100,000 IRA and you're a child of a parent who passed away, or you're a niece or a nephew of an uncle or aunt who passed away, and you inherited $100,000 of their IRA, you have to start taking out that $100,000 under the current interpretation of the Secure Act, pro rata, 1/10 of $100,000. You got to take out $10,000 per year over the next 10 years, okay, after your loved one passed away. And you pay taxes on that based on your income tax rate, okay? That'll get added onto your income from your employment, and you'll pay income taxes based on your withdrawals or distributions from that IRA. So folks, there you have it, 4 taxes. We covered estate tax, we covered capital gains tax, we covered inheritance tax, and lastly, we covered income tax. Folks, hopefully you found this educational video helpful. If so, scroll down, post a comment, post a question, because a member of our team will get back to you as soon as possible. And also, folks, if you like to learn, pick up a copy of my book on Amazon, How to Avoid the Four-Headed Monster of Estate Planning and Elder Law, or pick up a copy at elderlawcare.com, because you will learn a lot. Hey folks, we'll see you next time at elderlawcare.com.